There we go. Hello, hello, hello. Good afternoon. My name is Natasha Robinson, and I am the creator and curator of Legaleaze, Please, a digital platform rather, that is designed to deconstruct, demystify legal language and to explain it in such a way that you can have access and knowledge of what is going on as it relates to legal language, legal terms, policies, and cases. I am here because I said that I was going to be following the George Floyd trial, and I would be here to explain, to answer any questions that you may have, and address any comments or concerns that you have as you are watching this. I also wanted to provide a legal analysis, if you will, of some issues that I have seen on social media that people have asked me about. And I wanted to do it in a way where we could be in, I guess, as safe a space as we can be, to be able to breathe, to be able to just take it in as we can. I know for some of us it is very difficult to watch. And I know for others, you may watch depending upon your availability or your capacity to watch this trial. It is very heavy. And I am just coming off of watching the CNN coverage where they just showed the murder of George Floyd, but from the perspective of the police officer's body cam. And to sit and watch that uh, I wouldn't wish that on anyone, because you cannot just watch that. And so I wanted to be able to come on because, as I said before, there are people who have been in conversation with me and have said, well, why is this going on, and what is happening, and what does it mean when this occurs? And so I just wanted to touch base with you about those things. And the majority of conversation that I want to talk about today is exhibits and evidence. That's what I want to talk about. I want to talk about exhibits and evidence. You heard, or rather, you have been hearing for the last couple of days, the prosecution's case in chief, which means that they have the ability to call witnesses and have those witnesses testify about what they saw, about what they heard, and how it relates to the case. So for the prosecution's case in chief, the main thread through all of the witnesses that are testifying is that the defendant, in this case, Derek Chauvin, is guilty of second-degree murder, of third-degree murder, and of second-degree manslaughter. Those are the charges that are against him. All right. I forgot to mention that if you are here, please put in the chat, put in the comments that you are here so I can acknowledge you. And I also want to acknowledge those who will be watching the replay. We thank you for being here. So just by way of recap, there are 3 criminal charges against Derek Chauvin. It is second-degree murder, third-degree murder, and second-degree manslaughter. I want to be clear that none of these criminal charges involves intentionality or being purposeful. In other words, he is not charged with the type of killing where he is being said that he intentionally took the life of George Floyd. He purposefully took the life of George Floyd. That's not what he's charged with. He is charged with the type of crimes that said that he was reckless in his execution of his official duties, or he was negligent in that he knew or should have known, or that he should have been, hey, Reverend Schaefer, that he should have been more careful, if you will, in the execution of his duties. And so intention is not, has not, will not be on the proverbial table. Okay. It is about his recklessness and his negligence. Now, I hear you saying, and I have heard said Well, how is it that he is not charged with intentionality, the type of murder where he intended to kill this person? Because the video shows former officer Chauvin on the neck and the back of George Floyd while he is laying on the ground, and while his Chauvin's full body weight is on top of a handcuffed suspect, a suspect who says that he is afraid, a suspect who says he is claustrophobic, a suspect who you can see if you've ever seen this video that they showed, he is literally having a breakdown and he is pleading with the officers to have mercy. And when the officers throw him to the ground, it is then you start to hear him saying, "I cannot breathe." And when he is calling out to his mom and saying, "Tell my kids I love them." This is what is going on. So how can this man, Chauvin, sit on top of another man who is in custody and it not be intentional? I don't really have an answer for that. I have a couple of educated guesses. And one of those guesses is we live in a space and a time where it is difficult for people to believe that police officers kill civilians. I'm just going to say it straight away. Because what happens is in the trials that I have done, when I have asked questions like, do you automatically believe the testimony of a police officer? Or do you believe that the police officer has unlimited, unchecked permission to do what she or he wants? And most jurors would say, yes, I do believe that, because there was a time, certain generations and certain populations would say that officers officer friendly. If I ever have a problem, I go find this officer. If there's ever something that I need to have happen, I go to this officer. This officer comes into my school. This officer, why would this officer lie? And there are populations of people who believe that. And those who do not automatically believe a police officer, in my opinion, are in the minority number. And so strategically, what I think the prosecution did is they went with criminal charges, which they felt they knew they could prove. And so even though we see Derek Chauvin sitting on the back and the neck of George Floyd, and we believe it's intentional, remember, I told you yesterday, there is a difference between factual guilt and legal guilt. And the factual guilt is that Derek Chauvin killed George Floyd. But the legal guilt is whether or not Derek Chauvin broke the law, meaning, is there a connection or causation between the actions of Derek Chauvin and the murder of George Floyd? The defense has not presented their evidence yet, but where they're coming from, they've kind of given hints in their cross-examination. They have given hints that because of the crowd, they are going to argue that the crowd is what mandated or necessitated Derek Chauvin to do what he did to kind of calm the situation. Which my thing is, if the crowd was as crazy as they are going to claim, then you know what? George Floyd would not have been the only person who would have been harmed or killed on that day. Secondly, they could have called a backup to restrain the crowd, but the crowd was not resisting. The crowd was not interfering. The crowd was screaming, "Get off of this man, check his pulse." And they were fussing at the police officers because they believed that what they were seeing was the life leaving George Floyd's body. And they were angry because you have officers that are supposed to protect and serve wearing police outfits and police uniforms on top of this suspect, which, by the way, what was he under investigation for, if you will? Passing a $20 bill that was fraudulent. Not any showing of weapon, not any showing of force, but allegedly passing off a $20 bill in a convenience store. That's what he was under arrest for. Okay, or at least that is what led to the police officers coming to basically eventually kill him. All right. So today, when we're talking about day 3 of the testimony, I have watched all the testimony from this morning. And then I watched the testimony of one of the men who was present when he broke down into tears watching the body cam, and they had to take a break. And then I just watched, there is one man that is testifying now. I don't know who it is, but I know through him, they are showing the body cam of one of the officers who was not testifying at this trial. So it's not the body cam of Derek Chauvin, it's the body cam of another officer who was present on the scene. So I want to talk about exhibits and evidence so that you kind of get an understanding, that you kind of get an understanding of what is going on here. Okay, so when we talk about exhibits and evidence, I want to say that there are 3 types of evidence. Okay, in any criminal trial, I suggest that there are 3 main groups of evidence. You have physical, you have testimonial, and you have demonstrative. Okay, physical, testimonial, and demonstrative. Physical is the type of evidence that you can touch. Okay, type of evidence that you can touch. So if there is something that is, let's say, if there is something that was recovered from the scene of an alleged crime, okay, it could be bullet casings, it could be DNA, it could be hair, it could be blood, it could be what have you, whatever it is. If you can physically touch it, that is considered to be physical evidence. And the judge has the discretion whether or not to allow that physical evidence into the examination, if you will, of the jurors, if the judge feels that it's okay, or if it's physical evidence and it's a bench trial, where the judge decides guilt or innocence, then there is argument as to whether or not that physical evidence, which you could pick up, which you can touch, whether that is entered into evidence. The second group is testimonial evidence. Testimonial evidence is when someone is testifying. That's what we have seen so far. Someone takes the stand, they swear under oath that they promise to tell the truth, the whole truth, and nothing but the truth, so help them God, subject to, threat of perjury if they're lying. And then they proceed to talk about the personal knowledge that they have, either because they have witnessed something with their own eye. They may be testifying to something that they have learned as a result of the investigation in the case. So say, for example, the people who have testified so far up until this afternoon were persons who were on the scene yesterday and today. You had different teenagers and young people on yesterday, and then today you had the continuation of the Minnesota firefighter who was present on the scene. And then you had the store clerk, the young man who received the $20 bill, gave it to his store manager, and the store manager said, "This is fake, go get the real money," which incidentally, the person that received the $20 that was fake, he said he asked his store manager, "Can I just pay the $20? Can I just give it out of my salary?" And the store manager said, "No, go and get the money." Okay. And it's through the store clerk's testimony today. He said, "You know what? I feel so guilty because of the fact that had I just taken the $20 bill, none of this would have happened." And you could see him fight back tears because he, as well as other persons who have testified, they either feel extremely guilty, they feel shame, they feel extreme remorse and trauma because of what they have witnessed. And some of them have said they wish they could have done more, which is both saddening and angering because the person who really did do it, you can tell by his body language on the video as well as in court. He is unbothered because in his mind and in his actions and in his arguments through his attorney, he did nothing wrong. This was just another day. Okay, but I digress. So the first is physical evidence, which is evidence that you can touch. Think bullet casings, think bullets, think DNA, think hair, think blood, anything like that. Okay, that's physical. Testimonial is the evidence or the testimony, the spoken word of persons who are either present on the scene or who have personal knowledge about what is occurring. And then demonstrative evidence is a type of evidence that demonstrates or helps the trier of fact, the judge or the jury, helps them understand who is who and what is going on at the time of the event. Because, of course, most cases, there is a window of time between when it occurred and when there is an actual trial. And so what happens is that demonstrative evidence are maps, images, photos, and that lets the trier of fact, the jury or the judge, see what is happening and the perspective of the witness as they are testifying. So today you saw one of the witnesses, he was in front of the it's not a body cam, but he is in front of a screen as he's testifying. And there's a screen for the prosecutor, and then there's a screen that is in the courtroom where opposing counsel, the defense, and the jury can watch. And so the prosecution asked one of the witnesses, circle where you were when you first arrived on the scene. And so the person who was testifying circled it. Okay, that's the visual evidence, because we all process information in our own ways. Some of us, once we hear it, we got it. Some of us, when we see it, we're visual learners. We got it. Others, we need to involve ourselves in conversation. We may need to hear it. We may need to speak it out. Others of us need to touch it. We're tactile learners, which is I retain information better if I touch something that connects with my cognition of what is going on. Okay, so demonstrative evidence seeks to meet that expectation of those who know nothing about the intricate workings of the trial or different facts. What happens is that demonstrative evidence, it could be an aerial shot, it could be a photograph, it could be a map, it could be a graph. All of these are to aid the trier of fact, who is either the judge or the jury, to understand what is going on so that they can make an informed decision, and this aid assists them in understanding what is going on in the trial. Okay, so that's evidence. Remember, there are three groups. You have physical, you have testimonial, and you have demonstrative. Now, some of the exhibits were some of the evidence were surveillance of the store. I don't know if they have the $20 bill in evidence. I'm presuming they do, but I don't know. One exhibit was aerial footage of the intersection in Minneapolis between a 38th, at the corner of 38th and Chicago Avenue or Street, which is where George Floyd was murdered. You had exhibits where some persons were parked behind the officers, so they started recording with their own phone. And then you had an exhibit of a video surveillance from across the street. So throughout the direct examination that the prosecutors were doing, they were using demonstrative evidence to aid the judge and the jury in understanding, okay, when I said I was here, there is a video that shows exactly where I'm standing. When I say that I was parked here and I crossed the street, there is aerial footage where I'm able to circle where I was, so that you were able to visualize not only where I am, but you're also to understand how where I am and what I saw connects to my testimony, which is saying that this person is guilty of all charges that is brought before him. All right, or against him. The second thing that I want to talk about is evidence. So we talked about evidence in terms of physical, testimonial, and demonstrative. So let's talk about evidence in terms of admissibility and weight. This is what I want you to know. I said yesterday that there is a difference between factual guilt and legal guilt. I have a good friend of mine, Kimberly Malone Lockett, who we used to practice law, and she would say all the time, it's not what you know, it's what you can prove. We have seen time and time again, at some point, either a redacted, a shortened, or an elongated video of Derek Chauvin taking the life of George Floyd. We've seen that. And so some of us, most of us, are like, I don't understand why there is a trial. It's clear that he kills this person, so why is there a trial? I'm going to tell you. Because again, just because we factually see that, there still has to be legal causation and connection between what Derek Chauvin did and how George Floyd died. The defense is going to say that because there were controlled substances within George Floyd, fentanyl and methamphetamines, and in addition to the fact that he may have had some health issues, they are going to argue that these reasons were additional factors into how George Floyd died. So they are going to argue that George Floyd died because of an intervening factor, if you will. So Derek Chauvin's neck and body weight on a handcuffed suspect, who we now know is George Floyd, was a factor in George Floyd's death and not the factor. Okay, that is important to note. Also, when we're talking about evidence, if you have a videotape, for example, so let's think about Eric Garner. Eric Garner was the man who was in New York, and he was selling things on the street when New York Police Department approached him, told him he was under arrest, and he, in his dying, kept saying, I cannot breathe. They used a chokehold against him, and it was about 4 or 5 police officers that tried to take him down and eventually were successful. There were a myriad of videotape surveillance that recorded that murder. However, there were no legal charges brought against that police officer because factually, we may have all agreed that he was murdered by the police, but legally, there were those who were on the grand jury that says, no, I'm looking at the same thing you're looking at, and nothing he did was illegal. So if that officer had been charged with the murder of Eric Garner, just because there is videotape surveillance does not automatically mean that that videotape surveillance is going to be admissible. What does admissibility mean? It means when you have a piece of evidence and you want to have this evidence go toward the guilt or the innocence of a person who is charged. It is the judge, by using rules of evidence, which are prescribed on the federal level and the state level. It is the judge who decides whether or not evidence is admissible. So just because you have 10 different sources of videotaping, that does not automatically mean that those 10 surveillance tapes are going to come into evidence. There are challenges, if you will, and hurdles that you have to overcome in order for evidence to be admissible. It is not automatic. Okay. And if someone is trying to offer something into evidence and there is an objection, that person sometimes has to state what that objection is. Some objections we have heard before. Relevance, which is what you're talking about or what you're offering as evidence, has nothing to do with the conclusive issue of whether or not the suspect is guilty or not guilty. Another objection that we hear is foundation, which means even though you tried to offer whatever it is into evidence, you have not established when was this taken, how has this been kept in evidence, who was present, is it really what you say it is? Okay, that is the objection of foundation. We also have objections of hearsay, which is you want me to believe that because it was said outside of court, it must really be true. Okay, all of these are different objections. And when I tell you there are a boatload of objections, I'm just raising 3 of them. Okay, that affects the admissibility of evidence that is offered to the judge or the jury. Now, let's talk about weight. Just because something is offered to a judge or jury to assist in the finding of whether or not someone is guilty or not guilty does not mean that it is 100% believed. Here's my example. And I'm giving a real example. I had a jury trial where there was a client of mine who was charged with driving while license is suspended or revoked. And what happened is that he was driving home. No, his wife was driving home from a family gathering. This was around Thanksgiving. And as they were driving home, his wife, who was living with mental illness, started to have an episode. And they were about maybe 2 blocks from the house. So my client had to make a decision. Does he let his wife continue to drive and risk his wife and his life while she has this episode? Or does he break the law and drive them the remainder of the way home, even though his license is suspended or revoked? So he made the latter decision. He calmed his wife down long enough so that they could switch places and he could drive home. So she is now in the passenger seat and he is now in the driver's seat. As he's getting ready to take off, there is an officer who is bearing down the street and they almost get into a car accident because the officer did not see my client, about to pull off the shoulder. The officer arrests my client, despite my client telling the officer my wife is having a mental breakdown, an episode. The officer arrests my client and charges him with driving while license is suspended or revoked. We get to the trial. One of my client's witnesses was the doctor who was treating the wife. Now, the wife cannot testify, not because she doesn't want to, but because her breakdown did not permit her from remembering what actually occurred. So she didn't remember. It was a total blackout for her. But I was able to get the wife's doctor in to at least talk about her medical issues with her consent. So you have a medical doctor who is on the stand, a psychiatrist who is talking about the medications that he gives her. What happens when she doesn't take her medication? The side effects she could have. What is her affect if she should have some type of breakdown or episode? Okay. When the jury was deliberating, eventually what they told me was they did not believe the doctor. They did not believe that the doctor who was treating my client's wife was as forthcoming as he could have been. That was some people. There were other people that said that does not negate the fact that because his license is suspended, he should still not have been driving. This is what I mean by the weight of the evidence. You can get evidence in, but that does not mean that it is given the full thumbs up, the full 100%. We believe you. Okay. And in the state of Illinois, I'm sure in other states, but definitely in the state of Illinois, there are jury instructions. Jury instructions give jurors the information about how you are to deliberate the case, how you are to perceive evidence, that no one's testimony should be higher than the other. And when you consider an expert witness, you should consider it in this way. There is a jury instruction that talks about the weight that should be given to evidence and the admissibility. And so in this case, in Derek Chauvin, even if you have 10, 20, 100 different perspectives of Derek Chauvin killing George Floyd, that does not mean that just because that evidence gets in, that it is given 100% credibility or belief. Okay, so this is the answer to those who were saying, why are we even having a trial? We're having a trial because, one, factual guilt does not mean legal guilt. 2, just because you have evidence does not mean it's automatically admissible. And 3, it does not mean once it is admissible that it is given 100% weight or credibility. Okay, so I'm just going to pause right here. I'm going to look at the questions or the comments. If you are now joining us and you haven't had a chance to do so, welcome for being here. Make sure that you put in the comments that you are here. Any issues or concerns that you have that you've been thinking about, that you've not quite known what to do with or who to ask, this is where you put it in the comment section so that I can see. Okay, Carla says, this is from yesterday. Why was the photo of the minor witnesses admissible without covering their faces? Great question. The answer is, I don't know. I don't know. And the reason why I don't know is because if the prosecution took so much care and time in making sure that no one saw the person that was testifying, why would you then show them identifying themselves in a picture? The world that has been watching and listening to this testimony is the same world that is now looking at this picture, and it doesn't take anything to find anybody. So I don't know if that was a misstep on the part of the prosecution, on the part of the network, but we were not supposed to see her identifying herself. Now the jury can see, the judge can see, the defense attorney and the defendant can see, but I don't think that we, the public, were supposed to see. And the reason why I say that is because we had not seen her face all that time that she was testifying. So I don't know why that photo was showed. I think that was a misstep either on the part of the network or on the part of the prosecution. Okay. Hey, Lola, how you doing? All right. So that is my analysis. Do you have any questions or concerns? Please put it, in the chat. We're not on the Zoom. So of course, if you are on Facebook, if you're on YouTube, of course, all your questions or your comments come here, but I can't answer what you don't ask. Okay. So I'm trying to see, I'm just going through my notes to make sure I did not miss anything. Let's see. Okay. So there's only one other thing that I want to talk about. Oh, okay. If he is not found guilty, what will be the next step? Well, there's already been a civil settlement in which the family received so many millions of dollars because the civil settlement, think about it this way. The levels of burdens of proof are this. The criminal cases are the highest level. The prosecution has to prove the suspect, the accused, the defendant, guilty beyond a reasonable doubt of every element of a crime. I want you to think of elements to a crime like ingredients are to a recipe. If you are making a cake, some ingredients that you need would be sugar, eggs, butter, flour. If you miss any ingredient that is necessary to make a great cake, or you use too little or too much of the ingredient, the outcome may not be what you perceive it to be. So if you don't add enough sugar and enough flour to your mixture, what you're going to get is cornbread instead of cake. Okay. If you want cake, you have to follow the recipe. Now, I'm not talking about, when you had the type of grandmamas and aunts or granddads who was like, okay, we just going to put a pinch of this and a pinch of that. I'm not talking about that. I'm talking about when you're actually following recipes. Well, in criminal law, it is the same or similar to me. The prosecution has to prove each ingredient or element of the crime, because if they don't, then it is going to resolve in either a lesser included offense, which you get less punishment, or you get a full out acquittal. Okay, so in the criminal case, the highest level is proof beyond a reasonable doubt. The next level is for civil cases, where you are not suing for the incarceration or punishment of a person. You are suing for a payment. either to restore you to the place that you were before the incident occurred, or to punish you in an effort to show to other people this is not what you do. Because if you do it, then you are going to your outcome is going to be civil liability by way of there being some type of prevention from you to do something, or you have to pay because you did something. Okay, that level is called preponderance of the evidence, which is lower. So criminal is because you are facing the loss of your liberty or your freedoms or your ability to move around. Is this person guilty beyond a reasonable doubt? That's criminal. Civil is it more likely than not that they did it? And you be like, I mean, I'm not 100% convinced, but I'm at least 51% convinced. Okay, that is the threshold for civil. And so at the civil level, the city awarded the Floyd family, I think it was like 40 something, 50 something millions of dollars to the family, minus legal fees. Okay. So that has already been done. The only other thing that could be done is a federal investigation, where now you have the Department of Justice coming in to see if Derek Chauvin violated George Floyd's civil rights. Okay, so if he is acquitted, there's a possibility of maybe that coming down the pike. But other than that, I don't know if there are any other steps. Okay, so I hope I answer your question. Carla, is it just me, or does the defense's questioning seem to be off? It's not just you, it's horrible. They are asking questions in such a way that it seems to take forever to get to whatever point they're trying to make. Is this some sort of technique that made persons don't understand, but is nevertheless effective? I'm saying, as a defense attorney, a former one, it is not effective. When you are cross-examining a witness, the goal is to try to reinforce the belief that your client is not guilty, but you are also trying to, in my opinion, you're trying to expose that the witness that you're cross-examining is either lying, mistaken, biased, or any, mixture of those. And so the technique that is used for cross-examination is you don't ask open-ended questions, which you do for direct examination. Let me give you an example. Direct examination. If I said to you, where are you right now? What time is it? How did you get to your location? Have you decided what you wanted to eat for dinner? Why did you make that choice? When I'm asking these open-ended questions, the focus is on you to paint the picture with your words. Cross-examination, you don't want the attention on the witness. You want the attention on the attorney, because I'm not asking you, technically, I'm telling you. So the example that I give to my students is, if I am dating someone and my boyfriend and I have been waiting to celebrate our anniversary. And then on the day of our anniversary, after I have, told my girls I'm ready to go, and this is my outfit, these are my shoes, my boyfriend calls me and says that he can't make it because he has the flu. And so I'm all upset, and I'm like, babe, why didn't you just wrap up? This was our anniversary. And he was like, you know what? Just, calm down. We'll celebrate it. We just can't celebrate it today. And so I say, okay. He says, you know what? Just go with your girls. I'm going to stay home. I'm going to drink some hot toddy, and I'm going to feel better. And, I'm wiping my tears and stuff. And my girls, like, what? And I'm like, okay, we're going to go to the movies. We get to the movies. Of course, this whole fact pattern is before the pandemic. We get to the movies, and I'm standing in line, and I'm scrolling through social media because, I got to check in and let people know, where I'm at, because that's what I do. And as I'm scrolling through, I see a picture of my boyfriend at the same theater where I'm at. He's actually behind me, and with him is a girl that I have never seen. Okay? Direct examination is, can you tell me why it was that you lied to Natasha? How did you get to the theater? Who did you come to the theater with? Why did you act like you were sick when you were not? That's a direct examination. Cross-examination was you standing in line at the same theater that I'm standing at. You told me that you were sick, but in fact, you were lying. And then you had the nerve to come to the theater. And when you got to the theater, you brought another girl. And you happened to go to the theater with another girl on my anniversary. And now you got me out here looking bad to other people. So do you see the difference between direct examination and cross? When I am cross-examining my boyfriend, one, at that time, all he is really saying is yes or no. Because if he's trying to explain, my next question shuts his mouth up. The second thing is, I don't really care what his answer is because he's been caught red-handed. And so when the defense attorney is cross-examining these witnesses, he is, in my opinion, not really making coherent sense in what he is asking. And then secondly, the format of the question is for the witnesses to then explain themselves. And in cross-examination training, that is a huge no-no. You do not want a witness who is not on your side to have an opportunity to explain why they gave that answer. Okay, so I hope that answered your question, Carla. Okay, next question. If the jurors cannot all vote the same, what will be the outcome? Okay, so what you're speaking about is whenever there is a jury trial, the verdict has to be unanimous. That means everybody has to decide we're all voting guilty or we're all voting not guilty. If there is any discrepancy or if there is, okay, 9 says yes and 3 said no, what happens is after a while of deliberation, which is when the jurors meet with each other, talk about the evidence, they talk about the testimony, then if after a certain amount of time they don't all agree, then I'll talk about what's happened in the jury trials that I have. The jury will slip a note to the sheriff brings a note to the judge calls the attorneys and says, the jury cannot come to unanimous verdict. What do you want me to tell them? The prosecution says what they want to say. I was defense. I will say what I want to say. And then the judge say, I'll just tell them, keep deliberating. If after so many hours or so many days, there is still no unanimous verdict, the judge has the discretion to call what is called a mistrial or a hung jury, which is to say that the jury has deliberated. They cannot come up with a unanimous verdict. And so the judge is going to call a mistrial or a hung jury. Everyone goes home except for the defendant if the defendant is in custody. And then you do the trial all over again from the beginning. But this time you're walking into trial number 2 with a transcript. So if any of the witnesses say something different in trial 2 that they did not say in trial 1, then they can be impeached, which means their credibility can be called into question. Okay, next question. The notion that Chauvin's actions didn't cause Floyd's death seems absolutely absurd to me. Can a defense attorney introduce any observed theory they want to explain away a crime? Yes, absolutely. For example, if they wanted to introduce Wanon or any other conspiracy, no. Now, conspiracy theories are one thing, legal theories are another. You have a multitude of theories that the defense can introduce. So they're not just going in and saying the person that is known as George Floyd, someone switched the surveillance and that's not really him. That is something completely ridiculous. However, the defense can introduce legal sustainable theories to say why what Derek Chauvin did is but a factor in the link of causation. So what the defense is going to say is, yes, my client was on the back and the neck of the person, but 1, it was justified. 2, he was following Minnesota police protocol. 3, George Floyd had fentanyl and methamphetamines in his system. So by the time Derek Chauvin does what he does, there has already been a causation link that once Chauvin does what he does, that is a factor in George Floyd's death, not the factor. And if it is considered to be a factor, then that lessens the liability that Derek Chauvin has in the murder of George Floyd. Okay. Let's see. Hey, Mel Chris, how are you? Thank you, Daniel, for telling us it's 27 million. I don't know why I thought it was higher, but thank you for that fact. Good, Carla has answered. Okay. All right. So I have answered all of the questions that have been present or that have been presented. If at any time you think of something later, just come back to this broadcast, put it in the chat, in the comments, and then, of course, I will come and answer your questions. This platform, Legaleaze Please, has been intentionally and lovingly created so that we can have these conversations. If you are watching any legal commentary, besides the fact I don't really see a lot of sisters doing this commentary, aside from that, you don't ever see a question or answer period for the watcher to ask questions of the commentators. And nothing irritates me more than when a media person or someone who is giving a legal analysis does not ask, does everyone understand? Are there things that I need to explain? Or they give false information. And so what happens is that only the legal practitioners know it's false information, because unless you've gone through law school or unless you have practiced as an attorney, you know the answer. But of course, you're not on network or national TV. So I did not wait until I'm ever called on MSNBC or CNN. This is my platform. Okay, this is a platform where we are deconstructing law language. We are mystifying it. We are making sure that we have accurate and reliable knowledge, and that we all have access to that knowledge. Because if you know something, but if you're not able to get access to have the furtherance of that knowledge, it's as if you don't know. And I'm sick and tired of the criminal legal system continuing to disenfranchise persons based on. And one of the areas of disenfranchisement is the knowledge and access to understanding legal language, which is why I'm here. Okay, Yolanda, do you feel that the charges are appropriate? The evidence that we've seen so far. Do I believe they're appropriate? No, I do not. I believe that an argument can be made for first-degree murder. However, I know one of the things that I've learned in law school is they tell you got to know your audience. And I know that in this country, I can think of some cases where a judge says, prosecution, you went too low in your charges. And so I have to now acquit this person because you went too low. You didn't take the chance. You didn't have courage. I have also seen cases where the prosecutors went with what they thought and there was still an acquittal. So I think that the data has shown that when it comes to convicting police officers for the deaths of civilians who are in their custody, I think that the evidence bears out that the prosecution in these cases, go more with what they think they can win as opposed to what justice demands. I hope that makes sense. All right. Mel Chris, this is a great question. How do you decompress after so much information and grief shared in a trial? Man, let me tell you, I was licensed to practice in the state of Illinois and the state of Wisconsin in 1999. I'm still licensed in Illinois, but not in Wisconsin. I started working with the Public Defender's Office on March 13th, 2000. I left to teach law in schools in 2012. And I have been a professor of criminal justice since 2018. So from 2000 until 2021, I am still processing grief and information as things come to me. So I have a therapist. I've had the same therapist for, it will be 8 years. I talk to my colleagues. There have been many times where I have broken down and cried with my colleagues because I couldn't put into words what I was feeling, but I knew that they understood because they were doing the same fights that I was doing. And so this is why I love the public defender's office in Markham for so many reasons, because I was able to talk through my grief. And sometimes when I didn't have the words, when I only had the weeping, they were there and they didn't judge me. So my recommendation, if you will, is, therapy, journaling, getting in community with people who have shared experiences, and just be consistent with that. Because one thing I know about grief is you can't rush it. It will come at the most, I call it, inconvenient time. And there are sometimes you just have to sit with it and let it do what it do and be in a safe space, either by yourself or in community. So the persons that you are with understand that you don't have to say what you are feeling in order to feel what you are feeling. That's my suggestion. Oh, you're welcome, Daniel. Thank you. Let's see. That happened in a case in Chicago. Yolanda says a police officer shot a black woman and was found not guilty during a bench trial. Afterward, the judge admonished. Yes. And Yolanda, I cannot remember the name of that case, but in the judge's finding, in the judge's explanation, he did exactly what you said. He said, state, why would you charge so low? Because now you're tying my hands. Because while I don't think that the police officer is guilty of what you charged them, I do believe that the police officer is guilty of something higher. But because you didn't charge it, I can't find them guilty. Okay, Talia Boyd. Yes, Talia Boyd. That was the one where she was in a crowd or a party or something, and the police officer shot Rakia Boyd. Thank you. Shot into the crowd, and she ended up being killed. So you have that. You also have situations where the police have the audacity to blame the victim and the victim's family. Think about Quintonio LeGrier, who was a young man who was living through a mental illness episode, and his father called the police and said he's wielding a bat. I don't know who else to call. And so when the police finally arrived to the West Side, first they go to the home of Betty Wright, who they ended up killing, who they thought she was at the right address. They got the wrong address. They killed her. Then they ended up killing Quintonio LeGrier, and he was a teenager. So one of the police officers who was charged or held accountable, if you will, or accused for the death of Quintonio LeGrier, when he went to civil case, he sued the family of the young man who he shot, and then he sued then Superintendent Leroy Johnson, whatever his name is, Eddie Johnson, and sued the city of Chicago and said, I would not have killed Quintonio LeGrier but for your failure to train me as a police officer. Ain't that some shit? You killed my child and now you're going to sue me? So these are just examples of what is called the blue wall, where you have police officers protecting each other. You have systems protecting each other because the precedent of police officers being held accountable for their, I won't say mistakes because we all make them, their choices is, I'll tell you this, just do the research. Google civil settlements by Chicago involving police officers and watch how much money, and when I see money, I'm talking millions of dollars, have gone to families because the cities have settled, meaning they have come to an out-of-court agreement as opposed to going to trial. Okay, now I want to close with this, and I told this to my students today. as it relates to Derek Chauvin, this is my personal take. And it's because my platform, I can say it. That I don't believe that Derek Chauvin is just a police officer who is racist. I believe that Derek Chauvin is a racist who happens to be a police officer. And what do I mean by that? If Derek Chauvin had been a taxi cab driver, a chef, a teacher, a president of a company, a firefighter, these type of decisions that he has made would be evident no matter what profession he is in. No profession is independent of those who are carrying biases and prejudices, okay? Where prejudice and biases turn into isms is when you have the privilege and the power to execute your beliefs, your prejudice, and your bias. Think about what I said yesterday. We talked about weaponized discretion. He is who he is, Poppy, and that is irrespective of what his profession is. He would operate in the same way, because anyone who wears a police uniform in daylight and who doesn't care or doesn't care about who sees him or what he does indicates to me that privilege rules, rests, and abounds in his life. And he has done this before, and he believes that he will not be held accountable. That's what I believe. Okay. And so this is a person who is racist no matter what his profession is. It just happens to be him being a police officer. Okay. And so I say that to say, when we are paying attention to cases and laws and policies, we cannot be reactive and come after the fact. It's not as effective to boycott something when it's already law. Let's come in when it's a bill. Let's come in when it's their discussions and there are referenda. Let's understand that before we vote for a president of the United States, the people who affect us the most are at the state and the local level. When you're driving down the street, when you are voting for whether or not a school should get certain taxes, when you're trying to engage in deciding whether a certain locale should get so much tax money, those are things that affect you right then and there. It will take longer for something that the president does to affect you than it does what your local council, what your school council, what your state legislatures are doing right now. Okay, so we have to be vigilant. We cannot be narrow in our perspectives or in our view. We have to be able to look and know what is going on. You bring up a great point. Research your judges. I have a family member in my family now. When they would look at the judges, they would either vote for everybody because they didn't know nobody, or they would vote for the judges who sounded like they were in the same member of their ethnicity as they were. So if they saw a Johnson, they would say, oh, okay, well, they must be black. So let me go ahead. I got news for you. To paraphrase the Reverend Dr. Jeremiah A. Wright Jr., everybody your color ain't your kind, and everybody not your color and kind is your enemy, which is to say, I have seen more damage by people who look like me than people who believe what I believe. Okay, so you have to pay attention to judges. Just because a judge looks like you or sounds like you or whatever, that is not enough. Okay, a lot of times we don't know what judges are capable of until, guess what? We have loved ones or ourselves who are in front of those judges. And you know what? It's too damn late to research the judge then, because this fool is about to sentence me or preside over my case or do whatever. So research your judges. Okay, don't just get up in there and vote and say, okay, every third judge, I'm going to check a box. That is not how that works. Okay, you study the judges. Understand that when bar associations are giving recommendations of judges, they are giving recommendations of judges based on the judges who decide to meet with them. So if you have judge candidates that don't want to, for whatever reason, go in front of the bar associations, they automatically get a not recommended qualification. Not because that person is incapable, but because the bar association said, well, we can't comment on someone who is not come in front of us. And there are some applicants who say that the bar associations are not the best arbiters or decision makers when it comes to saying who I am and what I'm capable of. Okay? So understand there are systems within systems. Do not just eat what is served to you. Do your due diligence. Do your due diligence and make sure that you do it with reputable, sound, trained personnels who do not benefit from your lack of knowledge. Okay? Do your due diligence. I said to the webinar last week that there are some things you don't need an attorney or a judge for. You just need a stable Wi-Fi signal. And I know that that is privilege in itself because there are those who do not have access to stable Wi-Fi. But go to the library, read you a book, talk to people, and you can always come over here to this side of the internet because you know I'm not going to lead you wrong. I'm not going to lie to you. I'm going to give it to you straight, no chaser. And before I take it back, I'll add more to it. All right. So I just want us, in all seriousness, I just want us to be liberated in our language and liberated in our knowledge and liberated in our access. Because there's too many of us going into the criminal legal system, but not so many of us understanding what is going on or what is happening. And so I am here to make sure that that does not happen as long as I have breath in my body. All right. Any other questions or comments that you have? I said I was only going to be on for an hour and I am 2 minutes over. Did this make sense? Did this help you? I know I wish I could be in a Zoom so that I could hear you, but I can only hear you by what it is that you say. Okay. And the only way I know what you say is if you type it out. Okay, so I just want to make sure that I have answered all your questions, all your concerns at this point, because remember, there are still many more days. Now, I may not have a pop-up Legaleaze, or I should say a Legaleaze pop-up every day. I can tell you right now, I'm not going to have one every day. But I do want to make sure that we understand what is being said and what is not being said, that we are empowered with knowledge and access to that knowledge, and that we share it with other people. Okay. So if this helped you, if you are in a chat or a text message group or conversation, and there are some people who may be saying some things that are untrue, either because they don't wish to know the truth or they have not been presented with the truth, share this with them on your social media platforms. Okay. So that we can all be more empowered with the truth. Okay. All right. Yes, you can absolutely share this. Please share it. Please share it. I'm going to make sure that my settings are going to be such that you can share it from Facebook and you can share it from YouTube. Actually, Legaleaze Please has its own YouTube channel. Okay. And the YouTube channel, let me find it. Let's see. Let's see. Here it is. This is our YouTube channel. So whether you are on Facebook or whether you are on YouTube, you go subscribe, share, like, love, whatever the emoji is for thumbs up, share it on your pages. Okay. Knowledge is power. There are a handful of us who are doing what I have done in this last hour. Find them, listen to them, support them. Okay, because it is not easy to watch all of this information, wade through this information, and present it to you. Let me explain it to you. This is applied research. Okay, this is applied research. I may not be publishing it in a journal. I may not be presenting a paper, but this is research and it takes time. Okay, so support those that you believe have great information. Share this information. There are a number of people who are doing the same thing. And so this is my tithe. This is my service to my community because I care about y'all. And I would rather have this conversation on the outside than have this conversation standing next to you in court. All right? All minds clear? All right, so I'm going to end. I am 5 minutes over my time. If I should do another Legaleaze pop-up, just know that I will give you notice well in advance. But if you want to stay in contact with me, let me show you all of the platforms. You can email me at legalezeplease@gmail.com. I am the only one who reads that correspondence because it could be confidential in nature. And so I want to make sure that whatever you say is said to me and me only. You can follow me on Facebook, on Instagram, on YouTube, and Twitter. For Facebook, it's Legaleaze Please. You can go to the business page. You can also join the community of Legaleaze Please. On Instagram, you're going to see a pattern. Legaleaze Please. I showed you the YouTube. I'm also on Twitter. I'm out here in these virtual streets and I'm having conversations. And like I said, if you want to join the Facebook group, you can submit a request to the community of Legaleaze Please. And that is all I have for today. Thank you so much for your support, for your viewership. Please hit like. Please click share. Please talk about it, discuss it. If you have any questions, come back and put it in the comment section, and I promise you I will respond. All right? You all take care. And that's the benediction. May the Lord watch. All right. Thank you so much. You are welcome. And it is my pleasure. Have a great day. And make sure that you are the first person in line to take care of yourself. Because things that are happening in this world right now, you got to look out for yourself. And you owe no one an explanation or justification in doing so. All right. Take care. Bye-bye.